Hello, everybody, and welcome to Mediation Monday. This is our second installment. I'm Alan Crone, CEO of the Crone Law Firm. With me is Jim Latta, who's one of our affiliated mediators in the Crone Mediation section of the Crone Law Firm. And we're here for, as I say, for our second installment. And we're going to talk a little bit about what mediation is and how it's done and what the benefits can be specifically for litigants of various kinds of disputes. I always define mediation, and I think I probably picked this up in my mediation class. Mediation is a process by which a neutral third party, in this case a mediator, helps the parties to a dispute resolve the dispute. What it's not is a hearing or an arbitration or a trial or anything like that. And I think mediation participants are wise to approach it as a collaborative process by which the parties can control the outcome rather than a trial where a mediator is going to give some sort of decision. Mediator is not going to give a decision. Mediator may give you his or her opinion, may give you some guidance on what the likely outcome might be, but it's not a time for the mediator or anybody else to dictate to the parties. It's a time for the parties to figure out a way to reach common ground. Jim, did I get that about right? Anything you'd like to add to that?
I think you're right on about it. What I like to say about it is that it is flexible, it is voluntary, it is participatory, and it's a win-win. What I mean by that is if a mediation is successfully worked through to an agreement, it is flexible in that it can be applied to many life situations and very many conflicts, okay? It is certainly voluntary because persons who mediate, even if referred from court to mediate, it's still a voluntary process. What is required is that the persons participate in good faith, okay? But it's voluntary, okay? So the persons doing it want to be there. They see the value in doing it, so they're invested. It's participatory in that the mediations are between the participants. Like you say, Alan, it's not mini court. The mediator is called a neutral, as you say, neutral, which means the mediator is about the process, not about advising about law, not about rendering a judgment, okay, but about guiding a process in which the participants are the ones who do the work under, encouragement by the mediator, guidance by the mediator, resourcing by the mediator to resolve their conflicts. Therefore, that can lead to a win-win in terms of it being something that the people involved in it feel they have invested. And studies show over and over again that compliance with mediation outcomes is typically higher, much higher than a court-ordered outcome. That is to say, if I voluntarily do something and I agree to something voluntarily, I see the worth of the agreement to the point that I do want to make it happen, then I am much more likely to be compliant with what I have agreed to, what I have committed to. And that's very important in many facets of conflicts like family law and child custody issues and things like that, but also in many other realms of life, like employer-employee issues or probate court issues, which is much like family counseling in a lot of ways, family therapy. Same thing in therapy in that people do their best in therapy if they are invested in it, okay? I learned a long time ago, case in point, that if you charge someone nothing for therapy, zero, which, that is an attractive idea sometimes, zero, then you find that their motivation, engagement, follow through with the therapy and the recommendation therapy is diminished. If you charge them $1 or some significant or semi-significant amount and be really diligent about keeping their appointments as time, then they're much more likely to get more out of it. I think that's just human nature. Don't you think so, Alan? I mean, that's just the way people work. if they're
I
invested
agree.
in it.
I agree, and I think that for litigants sometimes, and even their lawyers, one of the words in that definition I laid out at the beginning of the show that they lose sight of is the word process.
Right.
It's a process,
Right.
and you have to get into the process. And if a mediator can get you into the process and get you participating and get you invested in an outcome and having an outcome,
Right.
then as you say, you're more likely to follow through on it, but you're also more likely to come to an outcome. And that's why mediations can take some time. It's not just a matter of, oh, give me your best position and give me your worst position and let's see if they overlap. I don't need a mediator necessarily to do that. What you need is to figure, as you say, is to figure out the emotional yes on both sides. And sometimes it takes a while to get there because very often these cases, even cases that appear to be all about money, are not about money. They're about other things. And so I think getting into the process and surrendering to the process is the key to a good mediation.
I think you're correct about that totally. And it is about the emotions. It's also about, I think, identifying on the part of the participants what it is they really want the outcome to be and why they want it to be that way. In other words, people can engage in behaviors for a variety of reasons. Some of them they're not even aware of, but a lot of them they are, okay? And, it can be an opportunity for the people involved to stand back and look at themselves and say, what are my motivations? What is the best outcome for myself in this situation? And what do I need to do to be flexible about helping to facilitate that to happen? And that means an emotional de-escalation usually of some type. Clearly the role of a mediator is to control the process and to encourage rational dialogue between the parties. And that's not always done outside of a mediation or outside of the courtroom. And that's important. You know very well that litigation sometimes has to happen. I'm not anti-litigation at all, but there's also an unpredictability about that, right? You don't know what's going to happen in a court of law. And you and I have both seen cases that have gone in a direction in unexpected ways, okay? In a mediation, the participants, like you said, have greater control over the outcome. And the person in a mediation that's responsible for the parties are the parties themselves, okay? And so mediation as a process is similar to counseling in that it helps the persons identify what their motivations really are and what is the highest form of motivation to lead to a reconciliation or an outcome that is a settlement. And that can be a very interesting process. And like you say, mediations can occur pre-trial, during trial, after court failure. It can happen at any time, okay? But it's probably most effectively done before trial when not all the costs are incurred and the difficulties and all the effort that attorneys and clients go to prepare for going to court, which is at best challenging, at worst arduous in some cases, as you know. It's reality and it's necessary sometimes, but if there's a way to probably arrive at a solution without delay of court, the cost of court, and I think, frankly, one of the most important parts of mediation is that what occurs in mediation, Alan, is confidential. It is not reported to the referring court. So there can be a freedom to say things in the mediation environment, even in two-room mediation with one party, one room, one party in the other room. For those participants to have the freedom to say, knowing that the mediator cannot be subpoenaed to court, no content can be subpoenaed to court, all can be reported to the court is the outcome. Is it a successful resolution of the mediation, and what are those terms, or did the mediation fail? And the studies indicate mediation more times than not is successful, okay, if it's done properly, well, and with the diligence, okay? So all those factors make it, I think, a very humane and also effective way to resolve conflicts. And with the court system as log jammed and overloaded as it is, this is a way to try to resolve matters that are not just time sensitive, but emotionally and financially draining. And hopefully the outcome will be more long lasting, more compliant, and in some ways more humane. Although in mediation, the participants may not get everything they want, but it doesn't mean they don't get anything that they want. Does that make sense?
It makes a lot of sense. One thing that if somebody's listening to this is worried about risk in mediation, there's very little. It's almost impossible to come out of mediation worse than you went in. I mean, the worst thing that happens is you don't settle the case.
That is
but
correct.
Your rights haven't been affected. Nothing
That's
you
correct.
say can be used against
Absolutely.
you. And I think that's something for people to understand as they go into it. It may alleviate a little bit of tension or stress or anxiety people have about mediation. Oh, I've got a mediation next week. I don't want to ruin my case. It's all, as I say, there's an exception to everything. It shows you I'm a lawyer, that I got to say that, but it's almost nearly impossible to walk out of a mediation worse than you walked in. You're just going to, you walked into the mediation with a lawsuit, you're going to walk out of the worst case scenario, you walk out of the mediation with the same lawsuit, same risks, but you also have the added benefit of hopefully you settle the case in the interim.
And that's a great benefit to the mediator, if I could speak selfishly for a minute, that it's really wonderful to be part of the process in which the parties do resolve their conflicts and walk out of there with a sense of a win-win. Now, that doesn't mean that the participants get everything they want, as I said, but it does mean that many of them walk out getting what they need. And I think that's a distinction of great importance. And what I need can be financial or relational or in some way, even self-respect, okay? But to know that at least that has been done and I made my very best effort, whether it succeeds or doesn't. There's a peace about that and there's a sense of dignity about that that I think is really important for the long term.
I agree. Well, this has been great conversation about mediation, the process in general. Next week on Mediation Monday, Jim and I are going to talk a little more specifically on how the process works and how each of the participants fit into that process. And I'm really looking forward to that conversation because I think it'll be very useful to people as they approach their own mediations. Jim, again, thank you for your time.
My pleasure.
And thank everybody for watching. This is Alan Crone, the CEO of the Crone Law Firm. Please join us next week for Mediation Monday. Thank you all very much.